Hi, this is Jennifer Collins, and we are reading in the Arkansas Real Estate Commission Regulations sections 8 and 10. I'm reading from the quick reference guide so that I can learn what it says. And this one is going to start at section 10.10, and we're going to read until like 10:15. Okay, 10:10. Agreements to be written. A. Except as provided in Regulation 10.10, a licensee for the protection of the public and all parties with whom the licensee deals shall see that the exact agreement of the parties regarding real estate is in writing. A licensee shall also see that the clients and other parties to the transaction with whom the licensee deals receives copies of such agreements signed by all parties. Examples are exclusive agency agreements or contracts, real estate contracts, closing statements, lease agreements, management agreements, financial obligations and commitments, etc. It is strongly recommended that a licensee obtain written acknowledgement from the buyer and/or seller that the buyer and the seller have received signed copies. It is strongly recommended that the non-exclusive agency agreements or contracts be in writing. In compliance with the Arkansas Supreme Court decision in the case of Pope County Bar Association, Inc. versus Suggs, Southwest 2nd, 828, actually it's 724 Southwest 2nd, 828 in 1981. Real estate forms used by licensees in the regular course of business shall be approved by a licensed Arkansas attorney prior to use. The licensee shall be responsible for providing evidence of such approval by a licensed Arkansas attorney upon request of the Commission. 10.1. Self-dealing. Licensees shall not buy, sell, or rent, lease property for themselves or for a corporation, partnership, or association in which they have an interest without first making full disclosure to the buyer or seller, as the case may be, of the exact facts that they are licensed as a real estate broker or salesperson and are buying, renting, or leasing the property for their own account and have an interest in the property which they are selling, renting, or leasing. All disclosures must be made in writing before the sales, rental, or lease contract is entered into. Okay. All right, 10.12. Offers and acceptances. All offers received on a specific property shall promptly be presented to the seller by the listing firm or other licensee designated by an authorized representative of the listing firm. B. Every offer received must be signed by the licensee who receives it and by the licensee's supervising broker. Every acceptance must be signed by the listing licensee and that licensee's supervising broker. It is desirable for the supervising brokers of the selling licensee and listing licensee to renew and sign each real estate contract before it is submitted to the seller. Although that is not always possible, however, such advertising or such supervising brokers shall review and sign the real estate contract as soon as possible after it is received and in all cases prior to the closing. 10.3. Listing agreements signs. A. If a firm holds an exclusive listing contract on a parcel of property, the selling licensee shall not contact the seller about showing the property or negotiating the sale without prior permission from the listing firm or other licensee designated by the authorized representative of the listing firm. Any offers received by the selling licensee shall be presented to the holding firm the exclusive listing contract not later than the close of the next business day after receipt of the offer. Likewise, all earnest monies and deposits shall be forwarded to the listing firm for depositing in the listing firm's trust account. The listing firm or other licensee designated by an authorized representative of the listing firm shall then present the offer to the seller. The selling licensee may accompany the listing licensee with the latter's permission, but shall not contact the seller without prior permission from the authorized representative of the listing firm. B. A licensee shall not knowingly enter into an agency agreement or contract when there is no reason to believe that there is an existing exclusive agency agreement or contract in force without first communicating with the other principal broker who holds such agreement or contract to confirm its existence. If there is an existing exclusive agency agreement or contract in force, the licensee shall not enter into another agency agreement or contract without first notifying the client in writing to consult with an attorney regarding the risk of being liable for two separate commissions. Signs offering or advertising property may be on the property only during the existence of a listing agreement, unless other authorized by the owner. 10.14. Reporting violations. It is the duty of each licensee to report in writing to the Commission any information coming to the licensee's knowledge which is or may be a violation of the Arkansas Real Estate License Law or violation of the Commission regulations. So if you know somebody been doing something bad, you need to tell somebody. Actually, you got to tell the Commission. Okay, 10.15. Broker's price opinion. A broker's price opinion means an estimate prepared by a licensee that details the probable selling price of real estate and provides a varying level of detail about the real estate's condition, market, and neighborhood, and information about sales of comparable real estate. A market analysis is similar to the broker's price opinion, but is usually limited to comparison to other real property currently or recently in the marketplace, whereas the preparer of a broker price opinion may utilize other basis for the report. In the preparation of issuance of a broker's price opinion or market analysis, usage of the terms market value, appraised value, or appraisal shall be presumed to be in violation of Arkansas Code and 1742-110D and subject to appropriate sanctions. It is highly recommended that a licensee avoid other general references to value of the property when preparing or issuing a broker price opinion or market analysis. A report in which a broker price opinion is prepared or issued by a real estate licensee must include within the body of the written report or in the separate cover letter the following. 1. A brief description of the subject property. 2. The basis used to determine the broker's price opinion to include any applicable market data and with regard to commercial properties, the computation of capitalization including the capitalization rate. 3. Any assumptions or limiting conditions used to determine the broker price. Examples: repairs, items to be removed from the property, zoning, change, new or different access other than what is currently available, special financing, hazardous waste, nuisance removal, etc. 4. A disclosure of any existing or contemplated interest of every licensee who prepares or provides the broker price opinion, including, without limitation, the possibility of a licensee representing the seller or lessor or the buyer or lessee. 5. The names and signatures of the licensee who prepared or issued the broker price opinion of the principal broker or designated executive broker with whom the licensee is associated. 6. The name of the real estate firm with whom the licensee who prepared or issued the broker price opinion is licensed. And 7. The date of the issuance of the broker price opinion. 8. In at least 14-point bold type, the following disclaimer. Okay, this is what there's like a disclaimer here that's in 14-point bold type. Notwithstanding any pre-printed language to the contrary, this opinion is not an appraisal of the market value of the property. If an appraisal is desired, the services of a licensed or certified appraiser must be obtained pursuant to Arkansas Code and 17-42-110. A broker price opinion or market analysis issued by a real estate licensee shall not contain the terms market value, appraised value, or appraisal. Any reference in the report to a specific marketing time period is for illustrative purposes only and does not obligate the licensee or broker to sell the property within the state time frame or act as a representation or guarantee that the property will be sold within such time frame. Unless otherwise indicated, the broker price opinion assumes without investigation of a fee simple title ownership interest without any reservation of minerals, subsurface rights, or otherwise. This broker price opinion report is to be used solely for the purposes allowed by state and federal law. If the report is to be used for any purpose not specifically allowed by state and federal law, legal counsel should be consulted. You got that? B. A licensee shall furnish to the broker or designated executive broker with whom the licensee is associated copies of all broker price opinion reports, including the cover letter described above, which shall be maintained on file in accordance with the record-keeping requirements of this chapter. C. A licensee may produce or transmit a written broker price opinion electronically to any person entitled to receive it. A broker price opinion that is submitted electronically is subject to any regulations relating to the record keeping as adopted pursuant to this chapter, including inclusion of the cover letter required in A above. Okay? D. A principal broker or designated executive broker is responsible for the preparation and issuance of a broker price opinion by any licensee who is associated with the broker unless the broker price opinion was issued or independently without permission or authority from the broker if the principal broker or designated executive broker learns that a licensee has prepared or issued a broker price opinion independently that must comply with the Commission Regulation 10.1 by immediately notifying the Commission in writing and forwarding such licensee license to the Commission. Okay, that's it for this one.